5 seconds to go. Start. Sir, thank you very much. I vehemently oppose this bill. If this law is passed, it will be an addition in the list of black laws in our country. My reasoning for opposing this bill is this. First, this will give extra constitutional power to the police officers from SHO level to presiding officers and magistrates. Secondly, this bill violates the Constitution in several ways, including Article 21 and the privacy of individual. My next reasoning is that this bill gives room for misinterpretation, misuse, and hence this is a badly drafted piece of legislation. This will not be confined only to the convicts for an offence, but this is like a double-edged weapon which anybody can use against their opponents. This is tantamount to giving an open general license to the police officers to work according to their will. This is really to terrorize people. There is not much time for me, so I come to the clauses of the bill. I do not want to narrate about the measurements, etc. The definition is given there, and everybody has quoted that. It is a lengthy list. The question is whether there is any part in the human body which remains for taking further samples. That is the only thing. Coming to the Act, I want to ask to whom it will apply. It is stated in A, B, and C. Clause C says, arrested in connection with an offence punishable under any law for the time being in force or detained under any preventive detention law. Is it not a high-handed kind of clause? Even for an arrested person, this can be applied. This really gives a kind of a weapon in the hands of the government to terrorize the people. Similarly, how can you say that a person detained or arrested is a culprit? Of course, you can try him, but at the same time, in the guise of doubts and things like that, if you use this kind of an act, it is something highly objectionable and condemnable in that way. Another thing is this. After collecting all these kinds of things, to whom are you circulating that? The bill says National Crime Records Bureau will be the central agency to maintain the record. It will share the data with law enforcement agencies. Further, states and UTs may notify agencies to collect, preserve, and share data in their respective jurisdictions. Sir, will such a provision not create trouble in this country? Without thinking about the far-reaching consequences of this bill, you have brought it here. Now, I come to the other things. My friends were saying that when you are making a law, you should be honest. Why are you making these laws? You are making these laws to disturb others or to victimize others. As an example, my friends were talking about the UAPA bill. What is happening in this? When you make a law with a bad intention, it will have a reflection throughout. For example, my friends were talking about UAPA regarding sedition charges. Even the Supreme Court had said that sedition charges should not be imposed in a simple way like this. Similarly, legislations like National Security Act are misused in a wide way. What is happening in anti-conversion law? On that account also, a lot of harassment is going on. What is happening under cow protection laws? What for have you made all these laws? I would like to ask, what was your intention? Your intention was to create enmity among the people. That is what your intention is. This law was really a law of prejudice. What is happening now? Innocent people are languishing in Indian jails even without trials. These kind of things are going on in this country. You are now adding fuel to the fire and bringing in such a legislation also. Towards the end, I would like to say only one thing, and it is this. What is the heart of a law? What is that? It is Article 14, which gives equality before law. That can be treated as a heart of the legislation. Now, what is happening? Are we making a law according to this principle, or according to your desire, or according to your political dimensions? You are making laws. Actually, you are spoiling the very spirit of justice before everybody and equality before law. This is in addition to it. Hence, I am saying that we oppose it vehemently. If the government is honest, and if they have got even an iota of sincerity, then I would like to tell them to send it to the Standing Committee of Parliament. With these words, I conclude. Thank you very much. Thank you very much, Mr. Chairperson. Sir, I rise to oppose the bill. Even at the time of introduction of the bill, I have vehemently opposed the introduction of the bill. I had demanded a division in this house, and there was a division also. At that juncture also, we were under the impression that the Honourable Minister and the government may rethink their political position so as to send this bill to the Standing Committee for close scrutiny. Unfortunately, the Honourable Minister now comes and is moving the bill for consideration and passing of the bill. It is quite unfortunate because this is a very contentious bill where the constitutional provisions are involved, human rights violations are involved, and so many ramifications or repercussions are there. Such a controversial or contentious bill will have to go through parliamentary scrutiny of a committee, either a select committee or a standing committee. But without sending that bill, even after having a division in the House with 120 in favor and 58 against the bill, the government is not willing to send the bill to the scrutiny of a standing committee is quite unfair on the part of the government. This is the first point that I would like to make here. I am opposing the bill mainly on three grounds. Firstly, this is total and clear violation of the fundamental rights enshrined in Part 3rd of the Constitution. Secondly, the right to privacy ensured by the Supreme Court in Puttaswamy's case is totally violated and abrogated. Thirdly, the human rights that have been declared in the UN Declaration of Human Rights are also not being respected in this case. These are the three main grounds on which I strongly oppose this bill, and I again request the government and the Honourable Minister to please have a close scrutiny of the bill by sending it to the Standing Committee or Select Committee or Joint Committee, whatever be it, according to the whims and fancies of the government. What is this bill? The Criminal Procedure Identification Bill is to replace the Identification of Prisoners Act 1920. The 1920 Act of the British India Government Law is more liberal than this bill. When we are in a reformed democratic era, we are making the law more rigorous and stringent and giving unfettered authority to the police officials, especially the law enforcement agencies, in respect of data collection and analysis, and that too at a time when the Data Protection Bill is pending for consideration before the Parliament. Its scrutiny is over. The Standing Committee has already submitted the report. Unfortunately, the government is not coming forward with the Data Protection Bill for consideration and passing. It has already been stated in the Puta Swami judgment with regard to violation of right to privacy, and the judgment is very clear that the law must be tested on the grounds of necessity, proportionality, purpose limitation, storage limitation, etc. These are the guidelines by which the Puta Swami judgment is saying regarding the legislative process, but nothing is being attracted in this case. The right to privacy under Article 21 states that no person shall be deprived of his life or personal liberty except according to procedure established by law. This is being taken away. Further, there are unchecked and unfettered powers to have police surveillance. Stop.